thrilled to have you join us visually from different places. My name is Mbalenhle Ndweni. I'll be your facilitator for today's event. So I'd like to start by our mission statement. Before we begin, I'd like to share the mission that drives this initiative. The mission is empowering young practitioners through strategic partnership and organizing programs in the built environment. This mission is at the heart of today's event, and we hope it inspires everyone as it does inspires us. I'd like to. Can everyone hear me?
Yes,
Yes,
we can hear
we
you.
hear you.
Okay. I'd like to move on to person who's gonna say the citation for the presenter, who is Engineer Junior. At this point, I'd like to invite Engineer Junior to give the citation for our speaker for today. Junior, are you here?
Good evening. Yes, I'm here. He's actually
Well,
Julius, not Junior.
Julius. Oh my
Yes,
God,
Engineer
sorry.
Julius.
Okay, my apologies, Julius.
No, it's
The
okay.
floor is yours.
Okay? Is it possible for me to share my slide,
Yes,
or I can just go ahead?
it should be possible to share your slide.
Okay. Once again, good evening, everyone, and I will be introducing our guest speaker as a way of reading his citations. Let me unshare this. Share. My apologies. I think there's a little mess up from my end, but I'll just go ahead to read the citations. So our guest speaker today is Dr. Ikpomusa Uhumwambi. He's an experienced legal practitioner, academic consultant, and thought leader for over 2 decades. He studied and worked in Nigeria, United Kingdom, United States of America. Also, he's also a senior lecturer and postgraduate research lead, School of Law, University of Greater Manchester. Dr. Ikpomusa has held various board positions in public and private sectors across Africa, United Kingdom, United States of America, including appointment as member of Edo State School Management Board. Thank you. So I think the speaker can take over from here.
Thank you very much, Engineer Julius. It is now my pleasure to hand over to our speaker, Dr. Ikpomusa Uhumwambi. The floor is yours, Doctor.
Yes, thank you very much, Promise. I really appreciate that, and thank you, Julius, for your kind words. I want to thank everyone here this evening. First, my thanks goes to Fortune for the invitation on LinkedIn. And then I just want to appreciate every one of you within the construction community for your kind invitation to share my thoughts this evening. I am grateful. I hope what I share this evening will be meaningful, will help you in your journey towards becoming active construction workers and managers in your areas of abode. I want to thank you as well for taking the initiative to put together a forum like this, because as Africans, one of the biggest opportunities which has been left untapped on the continent is the built environment. There's a lot of opportunities in that space. So I am so grateful and happy to find young Africans engaged in this. So please accept my hearty appreciations for this opportunity to share with you this evening. I will be speaking on the effect or the impact of artificial intelligence generally, and then more specifically to the construction industry. The goal really is to show how things have changed very quickly because of this technology. Before now, ideas around construction rested with a reliance on traditional modes of contracting and managing projects. But with the introduction of AI, we are seeing changes. I have titled this presentation AI in Construction Contracting and Dispute Resolution. It is important because with technology coming into the construction sector, not just as a tool for actually carrying out the construction itself, but as a tool for galvanizing the construction business from the contracting, from the bidding up till the delivery stage. I think it's important to discuss this and share perspectives with regards to how this particular technology is influencing changes within construction business. This evening, my argument is anchored on two principal planks. The first is that AI is changing traditional modes of construction contracting and dispute resolution with significant benefits to owners, sponsors, contractors, and other stakeholders. That is the first plank of my argument. And then the second plank of my argument is that without adequate precautions, the risks associated with the use of artificial intelligence in contracting and dispute resolution will occasion substantial risk or will occasion substantially high risk that may occasion irreversible damage to projects. Now you can see this technology is a two-edged sword. It provides benefits as well as risks. Now we're going to look at this technology and this argument within the context of what construction projects is or what they are. Construction projects are a complex mix of is a complex mix of interaction between multiple stakeholders, intricate contractual arrangements, and several unknown variables that may not have been contemplated during the contractual design stage. These challenges could arise as the project is being conceived or through the process of the project, including post-delivery. Challenges that revolve around increase in project delivery cost and time, which clearly are outside the expectations of the owner or sponsor. Also, there are multi-stakeholders with distinct and sometimes conflicting interests, which creates tension in the construction project itself. For instance, you might have a situation where a construction project manager or the contractor might want an extension of the time stipulated for the delivery of the project, while the owner wants this project delivered within time and cost. These differences in expectations can sometimes create challenges. Clearly, this is one place where conflict can arise. Because these interests never match, there's always this mismatch of interest. We needed an independent tool that will help shape the relationship, a dispassionate tool that will provide, a clear roadmap to ensure that the expectations of all stakeholders are addressed. Because AI in itself may not hold any interest in the project other than the delivery of the project. This is material as we move into aspects of dispute resolution. Therefore, the objective of this session is to critically examine the changing nature of construction contracting and contracts as a whole, and then the application of artificial intelligence to deliver a truly watertight project that meets all the expectations of all stakeholders. Also, we intend to critically assess the changing nature of arbitration procedures and other pre-arbitral stages within the construction dispute itself. To further narrow down on the specifics for the purpose of the colleagues listening to me this evening, we intend to assess the use of AI applications on construction, contract preparation, analysis, including arbitration agreements. We intend to examine the use of AI in construction disputes, an evaluation of the liabilities associated with AI development, deployment, and use within dispute situations in construction industry, as well as an assessment of the legal and ethical challenges in their development, deployment, and use within the construction sector or industry. Now, as you would remember, for those of you in the business of construction, there are two distinct, in fact, there are very many distinct models of contracting. But for the purpose of this discussion, I intend to share two. We have general contracts where individuals engage in contracts, or you have a state legislation that provides a basis for contracting for the purpose of construction work or building projects, road, rail, and all that. And then you have more specific contractual models designed by professional bodies. I've identified two here. The FIDIC, which is the contract, the special model contract from the International Federation of Consulting Engineers, which this particular contractual model is extremely important because of its wide use. It's used in really big projects. It's very highly regarded within the international space, and it has various contractual forms, like Red Book, where the employers are designed, where the contract is designed in such a way that the employers take charge of the design while the engineers look after the contract itself. To the Pink Book, which is an adaptation of the Red Book, Yellow Book, Green Book, Silver Book, more or less dealing with turnkey arrangements. Green Book is for small projects, while the Gold Book is for real big project, concession project like the build, operate, and transfer. So you find that this particular type of contractual model is extremely powerful and useful. So within these contracts, you have standard templates, standard clauses that are designed specifically, agreed across this professional body as the clauses that will regulate the interaction between the parties. And then you have these FIDIC contracts deployed at various levels with its own distinct traditional modes of dispute resolution. where you have dispute resolution boards like the Dispute Avoidance Board DAB or the Dispute Avoidance Adjudication Board DAB. So you find they have, it's all inclusive. It's all inclusive contractual design that speaks to that particular industry. So parties decide to use, parties may come together and agree to use the FIDIC contract, which is more international and speak to various multinational projects. Then for the UK, we have one particular contract that is extremely popular. We call it the JCT contract, which is the Joint Contracts Tribunal. It also has the same feature as the FIDIC, but it's more localized to the UK environment. It has three principal contractual types, like the standard building contract, design and build contract, and the minor work contract. So clearly you find that these contractual arrangements already exist. Within the traditional space as well, you find that these specific contracts also have types depending on the mode of payment. Some are fixed contract, fixed price, lump sum contracts. You have some that are cost plus or cost reimbursable contract, and then unit price, time and material contract, target cost, and management contracts. These are the various contracts, and within this contract, you have clauses designed specifically to address areas of dispute. If you recall, when we started this presentation, I told you that these contracts exist to manage the expectations, the sometimes divergent expectations or contentious expectations of all stakeholders. Clearly, having a contract that is binding on all parties is important. But sometimes it's difficult for the contract to envisage future occurrences. Sometimes it's difficult for parties to see the full picture of a project from the conception. So there are chances that in the course of the project, challenges may arise, disagreements, fundamental disputes may arise. Therefore, these traditional forms of contracting have been designed to address these challenges. Sometimes it works. Sometimes it works. You find that it works. Other times you may find that it might create challenges, especially time and cost overruns. It might lead to sometimes termination of the contract of the contractor. It might lead to frustration of the entire agreement and parties will just hands off. We have seen disputes delay delivery of contracts, especially construction contracts, where the initial agreed price is overtaken by inflationary trends, and people are now looking for where to manage their losses. Clearly, disputes will arise in circumstances where parties may not be able to contain the aftermath of the unforeseen circumstances that could befall a contract. Because of the poor or the inefficiencies with the traditional forms of contracting, there is a need to look beyond the traditional forms. But again, it's important to understand that there is movement within the context of our definition of a dispute. A dispute is simply a disagreement between the parties. It usually happens when there is, like I said, performance issues, interpretation or implementation of contract issues. It comprises a formal claim against a party based on a breach of a contractual obligation requiring the invocation of one or more of the mechanisms for dispute resolution. Clearly, we cannot establish a dispute unless we can show fundamental disagreements with the parties and disagreements that are traceable to the actual contract itself. So, sources of dispute. We are speaking to the traditional forms of construction contracting here. Ambiguity clauses. Sometimes you bring in very inexperienced individuals or individuals that haven't got the experience in that particular project, because every project has its own uniqueness. So in the design of a contract, you must capture the entire framework to ensure that nothing is left out. So poor drafting can create challenges, can create ambiguities in clauses. Those ambiguities can further lead to poor interpretation or misconception of the intent of parties. Mismanagement of contractual obligations can also, it could be mismanagement in the area of payments, the cost of the project, payments, or variation or change order. It could be delays, it could be quality issues, quality of work. So these ambiguities and poor drafting can create challenges. Limited knowledge in a subject matter in an area, for instance, a drafter or somebody who is involved in actually putting the contract together may lack the necessary skill or expertise or updated knowledge on the industry practice or regulation, or may lack basic drafting skills, leading to ambiguity in clauses as well as mismanagement. Let's look more specifically at the areas where you find these challenges. Scope of work clause disputes. This is one of the most important areas, and if not managed properly within traditional structures, it could end the contract, could lead to termination. Now, improper drafting can lead to incoherent or ambiguous clauses where the scope of work is drafted in such a way that it clearly defines the project within a scope. But upon implementation, you find that there is need to vary or change the entire framework. A scope of work is usually associated with the project cost, contract fees, and ultimate measurement of the overall value of money, of the value for money argument. I know some of you may want to ask me what's the scope of work. Scope of work is the totality of what is to be done to deliver that project. A contract is supposed to capture in detail the scope of work, what is needed to be done, because that is what will guarantee, or that is what will inform the cost of that project. Now, in drafting a scope of work, you're expected to cross-reference the design, the details of this particular clause. You cross-reference it with the design drawing, plan, and specifications, so that nothing is left hanging. There are no gaps anywhere. Because failure to achieve this closure can lead to dispute, because somebody in the middle of a design of a project can say, well, that area wasn't covered in the scope of work, so we're not going there. And it might be an important area that would deliver that project. And then you keep going back to the owner to vary the terms, or you're going for change orders. And continuous change orders might fundamentally create a time and cost overrun, which works to the detriment of the sponsor. So challenges of this nature is rife with traditional forms of contracting. If unresolved, sometimes termination of contract can happen. Now, we have dispute in payment, especially with payment terms, provisions, or clauses. This is another very important area. If the terms arrangement is not properly streamlined. And then you have issues with mismanagement of obligations. When your obligations are not properly tied to the contract and it's not clear, it's not clearly defined, it could create challenges as well, where parties would mismanage an obligation what is an obligation? Obligation is the duty that parties owe to one another in a contract. So if they don't understand the contract, or the contract has loopholes and people, cut corners, avoid and try to minimize the effect of those obligations, it could ultimately affect the delivery of that project. And it is a potential area of dispute where one party feels the other party is not meeting the terms of their obligation. It could create problems. And when dispute arises in projects, it slows down the project, creating time overrun. And then with the inflationary trend, cost overrun. And then what about the goodwill? What about the relationships? A lot of things happen. So clearly, these are principal areas that results in disputes. While we have this, we also have a traditional mechanism for resolving these disputes. We have negotiation as a form of dispute resolution. In fact, this is the most widely used forms of dispute resolution because of its capacity to win the relationship, keep it tight and cordial, even after a disagreement. Parties can sit and agree and negotiate terms and agree and then move forward. Sometimes, it takes some time. Parties might struggle to come to some agreement here because, making compromises in a negotiation means you're giving up certain rights or obligations. So to an extent, it's determined really by the parties' willingness to negotiate. Again, you cannot compel parties to negotiate, but negotiation is a goodwill gesture. Parties cannot be compelled to negotiate. And the challenge with negotiation is, in the course of negotiation, you might give up certain information within negotiation that the other party might use against you in a court of law if the matter gets to the court or gets other forms of dispute resolution. So there are clauses that are inserted that would protect parties from, from using or prevent parties from using whatever is used in a negotiation in a formal court proceedings. So it's important at this stage to understand the benefits as well as the detriments of negotiation, but it's one of those useful forms of dispute resolution. We have mediation, where a party mediates a dispute between two parties. We have different forms of mediation, where sometimes you find the mediator will stay back and allow parties vent, and then they agree on what they want, and the mediator puts the agreements together as the final agreement of the parties. You have others where the mediator is more inquisitorial. He will come into the arena and decide based on what the parties have said or what their views are on the issue. Conciliation is also similar to a form of mediation where the conciliator is the one in charge of the conciliation process, making sure that a decision is reached and the dispute is resolved. Then you have arbitration, which is also another traditional form that is a lot more formal than the other forms I have explained, where parties present their matter in a formal process, and the arbitrator selected by the parties to arbitrate on the issue will give an award, and the award becomes binding on the parties. And then you have adjudication. This is a special form of dispute resolution, a traditional form within construction, this construction industry. We have the statutory or contractual. And then if you recall in our conversation around contractual model, FIDIC has a special system. We call it the boards. It sits nicely. It's a mix. It's a hybrid of arbitration and adjudication, where you have specialist boards that are created within the FIDIC contractual model to arbitrate or adjudicate on issues. And then you have some countries, like in the UK, we have what we call statutory arbitration, which has statutory enablement for it to become effective in resolving dispute. And then finally, you have litigation. So these traditional forms of dispute resolution have their benefits because we have human involvement. It provides opportunity for individuals to engage in judge, or you have individuals talking to themselves. When a dispute arises, a formal claim is made and parties are brought together to resolve that dispute. Okay, these are the traditional form. The benefits I have highlighted, which means parties are able to see eye to eye and have these issues resolved. The detriments are that you find that sometimes it takes time, costs, which will eat into the overall cost of the project. You find it will raise very bad blood between the parties, where they might ultimately lead to termination of the contract. At other times, it costs time, and then the secrets, some trade secrets are opened up during the course of this, making the entire process very uncompetitive, and it just sends a very bad signal to the entire industry in terms of disputes and the consequences that results from there. So because of this time overrun, cost overrun, and the challenges with the human intervention and the bias that comes with human activities in resolving this sort of dispute, other forms of dispute resolution mechanism are now being considered. Hence, the introduction of AI. With the advent of artificial intelligence in its current form, people have been playing, industry practitioners have been playing with the idea of having an AI-enabled dispute resolution mechanism within the construction industry. What is AI? AI is simply a decision-making tool. It's composed of 3 basic technologies, but there are others. You have computer vision, you have robotics, those other, you have other forms of AI, but these 5 technologies are the principal technologies you will find useful within the construction industry. Machine learning, deep learning, natural language processing, computer vision, and robotics. And then when you look at the AI taxonomy, you find that you have artificial intelligence, you have the type narrow AI, machine, deep learning, generative AI, large language model, and all that. So you just find that there. And then you look at the more complex one, where you find the various areas of the technologies within artificial intelligence laid out. Deep learning, natural language processing, computer vision, machine learning, robotics, expert system, knowledge representation and reasoning, speech recognition, virtual agents, chatbots, autonomous vehicles, recommender system, game playing AI, knowledge graphs, cognitive computing, swarm intelligence. More like a map of how these technologies, because many of these that are mentioned here are subsets of those 5 areas I emphasized initially. For the purpose of the construction industry, those 5 technologies are in active use. I'm going to walk you through how these technologies, how they are implemented, how they are mapped into the workflows, especially in the area of contracting and dispute resolution. Now, machine learning. You find that across the entire value chain of a project, including the supply arrangements, the supply chain, AI is mapped in very nicely to address different problems within the entire chain. For instance, machine learning, you use it to monitor health and safety compliance. So machine learning is extremely good in compliance as a whole, risk assessment, risk management, compliance, in contracting and dispute avoidance. It's also helpful in automated contract generation. obligation tracking, cost estimation to improve contracting and avoid potential variations that could potentially lead to dispute and conflict. So you can see some of the risks that are identified in traditional forms now being resolved using machine learning. Supply chain and logistical challenges that could lead to contractual breaches, time and cost overrun, with the likelihood of conflict and disputes, are resolved using machine learning. Then you have risk prediction to enable effective contractual provisions, clauses to prevent future conflicts or disputes in construction projects, as well as provide approach to ADR design in cases where disputes arises. So you're seeing a clear application of an AI technology in addressing some of the challenges that I've highlighted in the traditional form of contracting and dispute resolution. We also find, this is for machine learning. Now for robotics, monitoring and evaluation of project delivery in line with contractual arrangements. So sometimes you have these robots designed in human form. Other forms of robots exist as well. You know, they are very physical. They operate in a physical form, but the intelligence that power them are a mix of other forms of technologies that I have just described. If a robot is capable of seeing, then that is computer vision. If it's capable of reading text and understanding and drawing insight from text, that's natural language processing. If it's able to learn through the different forms of learning, that is machine learning. So monitoring and evaluating project delivery in line with contractual arrangements. So you have the contract baked into the actual memory of this robot. So which means it has it programmed into it natural language processing, where you can read text and take it in, and then the actions of the robot are automated to carry out tasks in line with the inherent program. And then inventory management of construction and on-site material, plants, machineries, in line with contractual arrangements. So you have a contract that is encoded, and then that program is fed into the robot, and the robot operates in line with the contractual arrangements. What this does is, by encoding this and bringing it within the context of the robot through automation, executions happen without human interference, because AI itself is an autonomous system. It operates based on the program. If parties have agreed to get this done through this means, and it's programmed and the program is agreed and mapped into the workflow, and the robot delivers accordingly, there is no room for disputes, because the human element that would have created these errors are removed. Now let's look at the third one, knowledge-based systems. You find that with natural language processing, computer vision, machine learning baked into these systems, tender evaluation, conflict resolution, risk management, waste management, environmental impact assessment, sustainability assessment, all forms of assessments are carried out prior to the project, prior to the start of the project, throughout the project process to completion. Compliance issues are being dealt with using knowledge systems. So the fact of human error is minimized because everything is baked into the robot. So you find that at the level of contracting, where the contract is being designed, you're already minimizing the risk. At the level of programming this into the machine, you also minimize it. And then you create a system of automation to ensure that you are able to execute on the occurrence of a particular action. The system executes automatically, minimizing errors. But we'll come to challenges with this. But again, it just shows you the potential this has, this particular technology has at the level of minimizing risks and addressing some of the challenges that lead to disputes. Now let's look at natural language processing. Natural language processing is good for contract negotiation, is used for contract negotiation and development, contract review and risk assessment, contract analysis, metadata extraction, contract summarization, translation and compliance, contract management, waste management, impact assessment, sustainability assessment. So you see, those areas that were hitherto left to individuals, to humans to deal with, can now be dealt with by these systems. Now let me tell you how this happens. AI has the capacity of prior knowledge and the capacity to read through volumes in split seconds. Some of these projects, once fed into AI has the capacity to read through a library of data across the world of similar projects to the project it is fed that is before it, and then identify potential areas within this particular project that could likely cause disputes. And then based on that prior knowledge, is able to identify in your current contract those clauses that would likely lead to disputes. So you are informed beforehand areas to negotiate tightly to minimize the risk of disputes. While the dispute is on, the system is automated to ensure that it is foolproof, minimizing the occurrence of risk. And if the risk is to happen, it's prevented. There are situations where in the course of a construction project, the machine, the system in the machine sends an email to the manufacturer to say, well, in a couple of weeks, the machine is going to go bad, so the repairer should come in. You are in your office working, and the repair man pops up and says, well, I just got an email from your machine saying that in the next 2 weeks, a fault will likely occur, so I'm here to resolve it before it occurs. That is the machine speaking to the manufacturer. Clearly, you have all this baked in now to reduce the likelihood of challenges happening. Now, we're going to walk through this process one after the other. I don't know how much time I have left, but I'll quickly do this. AI in use in construction contracting and dispute resolution. I'm trying to be very simple because it's important because it's a mixed audience. So the views expressed here is quite subtle. So I hope you're following. There will be room for questions. For contractual analysis, disputes in construction contract often arise from lack of clarity or misinterpretation. So natural language processing is capable of quickly analyzing and processing large volumes of contractual and associated legal documents to extract critical information that are unclear and could be misinterpreted. So even if you have humans design it, AI can go in there, pick out clauses that are ambiguous. It can highlight and identify discrepancies in contractual provisions and clauses that could result in disputes. It can quickly sift through existing case law to identify current legal rules and how they apply to contractual clauses with a view to predicting likelihood of disputes. You see that? Now we'll give you examples. Alice is a good example that Alice does this. It's a platform designed by Alice Tech using Oracle. They are capable of delivering this outcome. You have a new one that just came out recently, Harvey. Harvey is also another good one, used for contract drafting and analysis. You have HE Venture, we call it P-Point Analytics. It's a platform to service construction project from bidding, from the point of bidding till delivery, relying heavily on machine learning and natural language processing. We have other platforms like CoCounsel. It's a legal platform that enables contract drafting and formation. You also have Alice here for contracting. So you have a platform, this AI-enabled platform designed specifically for contracting. All you need to do is sign in, just put your ideas in there, and the system will generate contracts. And then you look at the contract and modify or use. You can through the chatbots, because most of these platforms have chatbots. So you speak to the chatbots and you interact with the chatbot, and through that process of interaction, a new contract is formed that appeals to you, that speaks to your specific needs and requirements. Then for contractual management, you have Evisol. In fact, this one is for the entire life cycle of a project, from project conception to management up to delivery. It covers it. Now, I also have HE Ventures there. Then for project life cycle, you have ideas within the Hub Center. Ideas are being constructed. Softwares are being developed to ensure that the entire project lifecycle is catered to. Now let's look at the benefits. AI has the capacity to sift through large databases to identify most dispute provisions in various contractual models. Okay? They can help you plan, they can help you identify points of negotiation and areas that require drafting for contract to avoid future disputes. They can look across contractual models. They can help you review models and identify the best suitable model for you. Because they believe at that point of contracting, you're already resolving disputes. You're already taking care of disputes that could arise. Analysis of data, similar to the construction projects, is achieved here. Analysis of data on prevailing political, economic, social, legal, environmental context in relation to that project. The analysis is done to inform you beforehand. So that will help you, arm you in the area of negotiation, arm you in the area of project, identifying the right price for the project, arm you in relation to how to monitor, how to price the project, how to evaluate the potential value for money argument. It helps analysis of data in the industry connected with your industry and the construction company's internal context in relation to the construction project. All these things is done through data analytics. Document review for dispute resolution. AI-enabled platform can scan and categorize large volumes of documents, emails, letters, other textual, audio, visual records in readiness for negotiation, mediation, conciliation, arbitration, adjudication, or litigation. It has the capacity to identify and highlight the most critical aspects of these documents,
which they have now decided to use to extort
for the attention of the legal team, judge, or arbitrator. It also has real-time benefits in monitoring the progress of projects and timeous reporting to avoid cost and time overruns. What about measurement of project progress and performance against agreed terms? What about identification and detection and prediction of likely risks to plants and machineries, like the one I explained to you? What about measurement of decision making and level of alignment with agreed terms? It's capable of doing this. We have a platform, CoCounsel. It does this. We have another platform, JD Supra. It does this. Heavily involved in negotiation, mediation, and conciliation. What about Clio? That's the Harvey AI. It does it. Arbitration. So you will now see within the industry that moves are now being made to develop arbitration rules that are in compliance with artificial intelligence. They're incorporating artificial intelligence into dispute resolution now. Discussions are on to properly embed artificial intelligence in arbitration, especially for construction disputes. Now, we have a particular platform in use for litigation in Brazil. We call it, this software is called Victor. The AI platform is AI-enabled platform is called Victor. It's in use in Brazil as a dispute resolution platform. These are the benefits, but what about the risks? We have privacy concerns. You put your data, you put your materials there, you put your contract, the contract between yourself and your clients, you put it out there on a platform. Who owns the contract? Can you prevent others from seeing your contract? What about very important data relating to yourself or your company in that contract that is thrown open to the whole world? How are you sure of your privacy? To what extent does the owner or the enterprise vendor or whoever it is that is in charge of the platform, to what extent do they need your consent before they can share? What about the likely risk of breach of data, revealing your trade secrets or your competitive edge? What about the owner? Will the owner, if, for instance, the owner, the contractor want to enter into such, do you want very important details, very confidential details that are captured within an agreement left open for your competitors? What about your bids? You put your bid on AI and somebody else is able to read through and then they gain that advantage. What about liability issues, intellectual property issues, black box issues? We're going to touch on all of these very quickly. Balancing the need for privacy, data protection, and autonomy and accessibility is important. A proposal to allow use of personal data in medical practice or any other practice based on the judgment anchors on balancing or relative risk to the individual versus potential benefit to society, public interest argument. That happened in the case of Primol versus Google UK Limited. I don't want to bore you with cases here. I'm very mindful that some of you may not be lawyers, so I will just shy away from doing that. I actually held myself from bringing out cases because everything about construction law, construction project management, construction contracting is case law heavy. I would have brought a lot of cases, but I felt there was no need for that at this stage. Maybe in future conversations, we might consider that. Then there's also a proposal to balance legitimate public concern for security and confidentiality versus the need to access the personal data to improve outcome and reduce adverse events in construction projects. How do you balance the interests of legitimate public concern for security and confidentiality against access to personal data? These are arguments. Liability risk, scarcity of statute and case law here is a huge challenge. However, insurance companies can bring liability actions against AI tools vendors or contractors or project managers or software engineers or data engineers or institutional review board. But how can you bring an action against AI when an AI is not a person? So if you put the materials on AI and there is a leak and the vendor says, I'm not the one involved in this, and the sponsor says, how did my information get out there? Who put the information in? Somebody's asking, okay, is AI leaked it? Because it's an autonomous system, maybe something happened and the information leaked, the data leaked. Who's responsible? So there's an accountability risk. Who do you hold responsible? You can't hold AI responsible because it's a machine. So you find that liability clauses will have to be drafted in, insurance packages will have to come in. But again, to what extent is that addressing the challenge it seeks to solve? Because you're trying to bring in AI to resolve a problem and minimize cost. But here now you are having to spend more taking insurance policies to prevent the likely risk, accountability risk, liability risk, and the risk of data breach. So the cost-benefit argument must be had here. Then the intellectual property argument. Who owns intellectual property to the content generated by AI? If AI generates those content and gives it to you, you prompt AI and the contract pops up from those platforms. Who owns the contract? Is it you that prompted it, or the AI that generated it? So can you lay claims to those contracts? So contract generated from AI, insight generated and published, inventions derived from the construction, because if AI is heavily involved in the construction work, any ideas, any insights, any information, any new information developed, who has the intellectual property rights to it? Is it the owner of the platform or the person who used the platform to generate that insight? Because AI cannot own. Then it has to be either the owner of the platform, that's the vendor, or the man who generated it. But the man who generated it didn't write it. He only prompted AI. He only put the information there and AI generated it from the available information that it has within the database. Is it the programmer, the person who programmed the AI to carry out the task? Who owns the content generated? This current dilemma is a challenge. Now, black box issue. We don't know how AI comes up with these ideas. Some people say it's mathematics, others say statistics, others say it's based on pattern recognition. But how does it come about it? How can we trust the decision making of this AI across the entire value chain and supply chain of a project? How can we release all these ideas to AI at the expense of human element? How can we vest this level of trust on AI when we don't know how it comes about these decisions? How does it achieve the classification and pattern recognition? What about risk of bias in data modeling and design? Algorithms, sexism, racial discrimination. Since we do not know how it arrives at decision, is it safe to trust every AI recommendation? Does the absence of scale levels and measures to determine the threshold of AI input in the entire value chain of decision making a major contributor to the black box issue? These are questions that we have not resolved.
Doctor?
Yes.
We've got 5 minutes remaining.
Okay. I'll wrap up now.
Okay.
The ethics of equity, equality, and access is also a challenge. We're talking about AI in construction industry, how many people can access it? It has advantages in terms of ensuring that parties are able to get decisions in good time. They are able to address the risk associated with construction projects by minimizing the risk at the level of contracting, negotiation, decision making, as well as ensuring that projects are delivered within the time allowed, giving the capacity to introduce, to embed smart contracts within the AI platform to help automate. You have a smart contract and you have a chatbot on it, creating that federated learning that will, apart from securing the platform itself, it also helps to ensure that learning happens whilst the system automates. Communication happens as well, because within the chatbots, you have natural language processing that supports that interaction and that continuous looped learning that happens within the system. These technologies help in resolving the risks, although they have challenges. Some parts of the world cannot even access the technology itself, let alone talk about the risk or benefits. Because they cannot access it, their data is not available to train. Because they're not participating in that economy, their data is not available to support the training. So the system has no idea, has no recollection of their own unique ideas. So those ideas are not fed into the training of AI. So they are completely locked out of that economy. If the AI is applied, it will discriminate against them because it has no clear understanding of these individuals, these demographic, these people from different cultures. I'll be very mindful in the way I coin this because it's important. But again, you understand that certain demographics, certain cultures will need to be incorporated to ensure that these resources are distributed fairly and equally for everyone to be able to access the benefits of this. The ideas around data, the methodology, the mode of collection, the metric for assessing their fairness, validity, effectiveness, safety, appropriateness are important in our consideration here. We need a test or a set of principles in our application of AI in the construction industry, especially for contracting and dispute resolution. Thank you very much, colleagues, for this opportunity to share with you this evening. I'm open to questions. Thank you.
Thank you very much, Doctor, for the insightful presentation. So you touched on a very important issue in the built environment, contracts. That is very critical. We are facing, as you've mentioned, it's one of the disadvantages on the traditional contracting, misunderstanding, misinterpretation of the clauses, because in as much as the goal between the parties, the contractor and the client, is a successful project, but the client wants to save money and the client wants to save costs and the contractor wants to make profit. So that leads to disputes. So we appreciate what you have explained to us, and also you've touched on a very important method that can be used, which is AI. As I've mentioned, that one of the challenges, it's misinterpretation of the contract. Then with AI, can assist that with being able to interpret clauses and be able to identify potential clauses that can cause disputes in future. So that is very important. I wish that this presentation can reach to, especially here in South Africa, most contractors to be able to adapt into applying and implementation of AI. Having been said that, can I open now the floor to questions directed to Doctor, and he may respond accordingly. Thank you. We don't have questions. Why is it so quiet?
I think there are questions. One Vincent
Okay.
is raising his hand, so maybe yeah.
Oh, yes, I see Vincent and okay, we'll start with Vincent and then is it Utani? And I'm using my phone, so I can't read phone. I think it's Folasat. I'm not sure info. I'm sorry about that. And Womotimi as well. So in that order, we'll take questions. Thank you. Yes, Vincent. We can't hear you. I'm not sure if it's my audio or.
Yeah, Vincent, kindly unmute and ask the question.
We can't hear Vincent. So I think while you fix your audio, we can move on to Kutani.
Thank you, Prof, for the insightful presentation. My question is on the adoption of this technology. Are there any countries that have successfully adopted AI in handling dispute resolutions, depending on the type of dispute resolution, if it's mediation, arbitration, or adjudication? And how did they overcome the challenges you mentioned, such as intellectual property and so forth?
Oh, thank you very much. Promise. Is that Promise or?
Oh, it's Kutanai.
Kutanai.
Yes.
Thank you very much for that question. Yes, we have test cases. We have some test cases we have several test cases in the UK. We have trials also in the US in the area of AI-enabled dispute resolution, but not in the form of a dispute resolution or a full-blown proceeding in an arbitration or a court. What we found is they are using this technology to minimize the risks that could lead to disputes. By so doing, these issues are being resolved at the level of contracting and the implementation of projects. We have seen cases where, in the UK especially, we've seen cases where a smart contract is embedded within the platform. Whilst the project is on, if there is an occurrence, monies, it executes in such a way that monies are paid to parties who may have suffered losses without the necessity of even filing a formal complaint. Because at the initiation, at the conception of the agreement, it was already baked into the contract that if there are delays in a particular process outside the terms of the contract, Mr. B gets maybe £10,000. And once that delay happens, before you even file a formal complaint, £10,000 is in your account because the machine has authorized it. Because at the initiation, that was agreed and baked into the contract, especially contracts that happen at the level of platforms. Sometimes you find within the contractual matrix, parties upon the occurrence of an event will just initiate a complaint through the chatbot, and it processes that complaint through the chatbot, and the smart contracts initiate payments directly into your account, obviating the need for a formal complaint. So you will find that complaints are now being dealt with automatically, reducing the likelihood of those complaints coming to formal and informal systems of dispute resolution, especially the formal one, the one I've highlighted. So you don't even need to lose any sweat. The machine has looked after that, except in circumstances where this has not happened. Except in circumstances where this has not happened, or maybe the default itself, was not contemplated at the conception of the contract. It's only then the machine the machine might defer it, and human agents might get involved. But these are also settled using the traditional forms. So in the UK, we are beginning to see minimal conflicts since the introduction of these platforms that I shared with you this evening. Some of them are largely reported. So we see the caseloads in courts, we see case law, we see the regularity at which cases now appear, either at the tribunal or in court, to show that some form of progress is being made in this regard. So I cannot speak to a specific case at the moment. Everything is still at the level of conception. I cannot speak to a specific case where AI has presided or AI has been used in a courtroom where the AI is deciding a matter. No. Although we're also seeing cases, we're seeing prototypes being tested in Brazil, like the Victor I mentioned. We're seeing all forms of interactions happening across those spaces where AI-enabled platforms can now resolve dispute. But resolving this dispute requires two technologies if AI is to be involved. And this is no longer happening in court. It's happening right on a platform. The interaction between a smart contract and a chatbot is solving that problem. It's a chatbot for the purpose of interaction, and the smart contract for the purpose of automatic execution. Anything programmed in, once a complaint is lodged through that chatbot and the information is sent in and processed, the system automatically makes a transfer based on pre-agreed terms during the contract. Payments happen without the necessity of involving a third party, saving time, cost, and maintaining the relationship and ensuring the continuity of the project. All these are now happening at the level of platforms. I hope I've answered your question.
Thank you, Doc. Yes, you have. Thank you.
Yeah, thank you.
Okay, we're gonna take the next question. I don't see Vincent anymore, so I think I'm gonna take a question from Ellen. Is it fine? Ellen, you can ask the question.
Okay, all right. Thank you very much, presenter, for a very beautiful presentation. Yeah, I want to ask, don't you have any concerns about AI having to make mistakes? Most of these models are being developed with historical data. Similar projects have been used to predict future projects. So what do you think about these AIs having to make mistakes although the models have developed over the years? That's the first question. The second question is, you talked about liability. There's a case currently. A parent is suing OpenAI. I think it's recently, for their child that was influenced by ChatGPT to commit suicide. So what's your take with respect to that? Don't you think the companies that have developed these models are liable should in case something go wrong? Thank you very much.
Yeah, thank you for those questions. Thank you. Good questions. First of all, on the question of mistake, yes, in the past we've seen cases where the system hallucinates. Hallucinates on the basis that, okay, the information is not available, they will make up. They will just make up a story because it's objective driven. It has a goal and it must achieve the goal. You've asked it a question, it must produce an answer. So if you cannot find any answer, it will make up one. We've seen those cases with AI, and that's why human judgment is extremely important. We've seen laws across the UK, EU, and within the international framework, legal framework as well, where there is a requirement that human involvement must feed into activities. That means even if you're using AI, you must disclose you're using AI in making a decision. And within that, a human oversight happened while you're doing that. Otherwise, you would be in violation of certain provisions, especially with the GDPR. Article 22 makes that clear, that if you must, EU GDPR, that if you must use AI in cases of autonomous decision making, you must ensure that there is sufficient human oversight. And you must disclose, so pursuant to Article 15 of the same legislation, you must make it known that yes, this is AI, it was used, but again, pursuant to Article 22, human oversight happened. That is to obviate the need or to reduce the likelihood of errors or mistakes. Again, mistakes happen. For historical data, on the question of historical data, especially with construction projects, historical data is always important in reaching a decision on future or the likelihood of future occurrences. For us as lawyers, we decide cases based on historical case law. Judges decide cases based on historical case law. If I have a matter in court, I'm not going to cite a case that happened in the future. I will cite a case that happened in the past and make my argument. So historical data is always important, especially for dispute resolution, because it gives you insight into the likelihood of a certain occurrence. You find that you don't expect that level of exactitude that it will happen the same way it happened previously, but it just gives an inroad into what could likely happen. It provides you that panoramic view of what could potentially go wrong based on what happened in the past. For instance, with these AI systems, you are able to sift through large volumes of data, identifying based on historic case law clauses that had been heavily disputed in various types of projects, because projects have their own unique characteristics, and the environment where those projects happen also, the demography, the context, the various human and material factors that are at play, the economic, social, political, and cultural. These are all featured in in doing a careful analysis and modeling of that particular situation before reflecting that in the likelihood of conflict happening. So it's not just a case of, okay, clause C happened in the US, clause D happened in Canada, therefore it must happen in South Africa or must happen in Nigeria. No, they will consider these countries in line with their own political, socio-economic, and cultural uniqueness, the economic environment, the situation with the project, and they will explore the similarities in the macroeconomic environment to distill the likelihood of that occurrence. So it goes through a measured procedure. Now, mistakes could happen where if the system automatically pays money to an individual that is not entitled to, that at that stage, the other party can dispute, and then the process is brought into a formal traditional process where both parties will now be able to meet and through negotiation resolve it. But at least to an extent, the fact that exists just it shows goodwill, that okay, parties are willing to part with certain amount of money just to ensure that this project continues and everyone is happy. So again, I see what you're saying. I see the point you're making. But yes, that mistake, that area is where the human element is required, where you guard against the likelihood of mistakes through human oversight. And then as touching on your second question, which is one of liability, it's a difficult one here because the question now is somebody is suing OpenAI that the chatbot convinced the child to commit suicide. This is a test case. Now, AI is not a person. It's not a legal person. You can't sue AI. Now they're suing OpenAI. The question is, did OpenAI instruct the chatbot to advise the party to the child to commit suicide? Did the child prompt the chatbot? The views expressed by the chatbot, are they the views of OpenAI? That's a question. Because we've seen cases where, especially in the area of intellectual property, it's clear AI is not a person. AI is incapable of owning anything. It's a tool. Now, which means the party the company who produces AI and provides AI as a public service is now being held and challenged. Providing a public service, the use of which OpenAI has no control. OpenAI cannot control what the chatbot says. The party who controls the chatbot is the person interacting with the tool. What OpenAI provides a mechanism for this. But the other challenge is, does OpenAI owe a duty to that child to ensure that not every content is available to that child? Or it has the capacity to censor what the chatbot can disclose to that child? We look at that against the duty of that child or the parent of that child who owes a parental responsibility to ensure that the child is not exposed, especially if it's a child within the age range. But if a child exceeds a certain range, you expect that child to have the right to own certain responsibility for taking the chatbot towards that line of interaction. So this has to be looked at from all directions in exploring the question of who is liable here. Can OpenAI censor or prevent the chatbot from expressing itself in a certain way, especially if the conversation is going in a certain direction? Yes. So OpenAI may have questions to answer there. But the duty of a child not to interact with a chatbot to that level is also there. Or the parental responsibility for exposing a child to such is also there. So this has to be on a scale to explore the competing interests that are involved here and the likelihood of liability springing towards questions of the duty of the vendor versus that of the user of the service. We're all waiting and anxiously expectant. We want to see what the court says here. I hope I've answered your question.
Yeah, sure, you have. Thank you very much.
Yeah, if you have a follow-up, I don't mind. I'll
No,
provide
it's perfect. Just like you have said, for the OpenAI.
Yes.
Let's see what happens.
Yeah, let's see
Then
what
from there,
happens.
maybe future cases can learn from that.
Yes.
Thank you very much.
Yeah, thank you.
Thank you, Doctor. I think I missed someone. I think it was
there's a Kansande, and then Folashade.
Yeah, Folashade is the one I missed from. I remember there was someone I missed. Yes, Folashade, you can ask a question.
Okay, good evening, everyone.
Yeah.
Am I audible?
Yes, you are.
Okay, thank you, Prof, for the insightful presentation. You discussed about the importance of AI and machine learning. My question is similar to Alan's question. In the use of AI for dispute resolution and decision making, don't you think bias can occur? Because you said not quite long that historical data are very, very important. I think when using AI and machine learning, historical data is important truly, but what if those historical data are biased and it's being used for dispute resolution or decision making? Hope it won't discriminate some sets of people.
Yes, yes, thank you very much for that question. Yes, that's what I highlighted in my in the risks. That's one challenge with this with the use of artificial intelligence, where historical data laced with bias might filter in, and AI, being an amplifying device or tool, might amplify the bias and make it more entrenched. Yes, it exists, but again, the fact that bias exists does not mean that we cannot use this service, knowing that the mechanism should be in place to minimize bias. That's why I referenced the potential of having human oversight. The fact that AI can take decision does not mean that we have removed the potential of having an appeals board to appeal against decisions taken by machine. That's where the human oversight comes in. Some of these traditional measures we've discussed here, some of them might swing in not as a primary place of commencing actions, but they might begin to sit in the form of an appeals board to decide decisions made by the machine itself. If the machine refuses to pay an individual, and for instance, as part of the contract, says, on the occurrence of this, I should be paid ABC, and the occurrence happened and the machine has not paid, you can file a complaint to the appeals board to say the machine failed to pay asset, and then the appeals board looks at the issue. Systems can decide to have an appeals board as well as a machine, which means you have a higher level of AI, the AI tool, to act in the capacity of an appeal, so that you sit at the very top. Maybe you have a board of a final board of arbitrators or conciliators or mediators sitting at the final lap to oversee decisions taken by machine at the lower and middle levels, so that before a decision gets to that higher body, it would have been developed, it would have been managed in such a way that the grievances by the parties are dealt with. Creating layers of dispute resolution mechanisms to address this challenge, providing a basis for individuals to air their concerns, would reduce the likelihood or the effect of any bias. Because if somebody feels I'm entitled to this particular contract, I have submitted a bid, and the bid was, we did an electronic bid, and the AI system did the selection, and my bid was thrown out. If it was an e-tendering system, I have submitted mine, and the decision was taken through an AI-enabled platform, and somebody got that contract. I have a duty to make my views known. In fact, I have a right to challenge the decision, and the organization that used that AI will have to show that the machine did not take the decision alone. That even when the machine had read the bid submitted by everyone, humans looked at it and a report was generated based on those selected and those refused, and reasons for refusal communicated to all parties. The extent of the use of machine must also be communicated in line with the requirements of GDPR. That reduces the likelihood of bias. Because once you bring in a human, because there's also bias within a human element, but that bias within a human element, we have a way of challenging it. If we can show manifest bias in decision making, you can challenge it under human rights. Discrimination. But with machines, it's difficult. So that human component has to come in. But the purpose of bringing in a human component is to ensure accountability. There must be someone, a human being in the loop that has to be held responsible, held accountable in case anything goes wrong. Because the fact of a machine is quite slippery. Hence, that human element. So whatever historical bias data is available laced with bias, once you put in you put that that data within a system that is accountable, you have layers of dispute resolution, even if orchestrated by machines, but you have a human in the loop. And then parties are given the opportunity to challenge any decision. There is accountability, there's transparency. The likelihood of bias is reduced. It's reduced. You can't rule out bias in everything. You cannot rule out bias. As human beings, people tend to favor certain things over others. So bias is part of life, but it has to be bias that does not put one party at a detriment in favor of the other. So the test must be one of that is proportionate. You must win that proportionality argument to justify the existence of bias. I don't know if I've answered your question, Fola Shade.
Yes, sir. Thank you, sir.
Thank you.
Yeah.
Thank you very much, Doctor.
Yeah.
Kutanai, I think this is the last question because we have run out of time. Can you?
Yes.
Okay.
Yes, Doc, is it okay if you can share the list of AI software? Unfortunately, I wasn't able to jot them out quickly when you're naming them that are tailored for specific
Okay, I'll pass it
services.
on. I'll pass it on to Fortune to share. I'll give it to Fortune to. Yes, I'll make it available.
Thank you so much.
All right, you're welcome.
All right. Thank you very much, Doctor, for the insightful information we've gathered here today. And as we wrap up, thank you once again to everyone who has joined us today. Please also stay connected and be on the lookout for the next event. You can follow the social media platforms, which is YouTube. It's Young P Construction, and also on Facebook, Young Practitioners in. Yes, it's in the poster. So please look out. We are looking forward to meeting you again on the next one. So it's going to be uploaded. The updates, they're going to be uploaded on the platforms I've just mentioned. Thank you again, everyone, for taking your time and being part of this event. Thank you.
Thank you, presenter. Thank you so much.
Thank you.
Thank you.
Yeah, bye. Bye for now.
Bye-bye.
Bye.
Yeah.